be a. It's also, it's a little bit of smooth it out. This would look pretty. Which I mean, typically it's the font size, so not too bad considering. Okay, yes. I tried taking out some effects because it was just podcasts getting bogged down. I'm sorry against myself. They can go into it. So they put me into there's not much record. It's strong. It's my thing. It's like I fade into the thing. Do that, for the staff, sure. You don't have the attorneys to. If you're worried about that, I think it'd be great sheets.
Put a blanket rule on the whole system, I guess.
Yeah, I guess that makes sense.
Something.
All rise. The District Court of Appeal of the State of Florida and for the Second District is now in session. The Honorable Anthony K. Black, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. You may be seated.
Good morning, everyone. I'd like to welcome you to the second DCA. This morning, we have 3 cases on our docket. We'll call them in the order that they appear. If you are the appellant, of course, you'll go first, and you'll have the opportunity to reserve some rebuttal time if you let me take care of that for you. And without further ado, we'll start with the first case, which is Richard Kloss versus Caliente Master Association.
My name is Francis Hannon. I have the pleasure of representing Mr. Richard Kloss, the appellant in this matter. I'd like to reserve 5 minutes for rebuttal.
Okay, sir.
Thank you, Judge. Your Honor, this case is taken on the order. This appeal is taken from a final judgment entered in the underlying action on September 23rd, 2022, which stemmed from an order granting summary judgment in favor of the Appellate Master Association on June 7th, 2022. As set forth in the appellant's brief, we've identified what we believe to be 3 issues that warrant the reversal of the underlying judgment below. The first is the trial court's conclusion that the statute of limitations, as applied, bars all claims asserted by Mr. Kloss in his Second Amendment complaint. The second is the trial court's conclusion that the 2012 membership vote held by the association did not require unanimous approval as governed by or was required by statute section 723.06(1)(c). The third issue is the trial court's conclusion that the calculation of the 2012 votes themselves could be resolved as a matter of law upon summary judgment. It did not present a genuine issue of trial.
Can I ask a question?
Yes, sir.
When I bought the property in 2007, I think, the Second Amendment was a record. The record. And so the shooting match here revolves largely around the ratification of it in 2012.
That is correct.
But your client had notice of it when you bought it, correct? So how does that affect your time bar argument?
So ultimately, and it's, I think in the record, and as even I think conceded in the appellee's answer brief before the court, there's this contention that the 2012 vote was taken to complete the process to fix an underlying issue, essentially in recognition of the fact that the 2004 and then by extension 2006 amendments that were unilaterally established that incorporated the subject property under the Master Association had some statutory deficiencies. And so as a result, the association made the decision to take it upon itself to conduct that membership vote to essentially put a bow on these issues, to ratify and update that 2006 amendment in particular, which brought or purported to bring the subject property under the purview of the Master Association. So from a time bar standpoint, we submit that the 2012 vote essentially constitutes the last element of the cause of action that Mr. Kloss could have brought against that vote itself, challenging its propriety, challenging its compliance with the applicable statutes.
It's kind of a non-sequitur here, right? Because you're not really challenging we'll use your euphemism, the bow. You're challenging the package. You're challenging whether or not this property the casita property is brought into the master declaration, and that occurs in 0406, right?
Apparently it's supposed to, and I think that's the issue. You're correct as far as the timeline, Your Honor, yes.
Okay, so one thing that kind of caught my attention is there's a little bit of an argument here on the statute of limitation issue about accrual. What is you all's position? I think you all's position is that statute of limitations here would begin to run if we don't accept the argument that the subsequent Bowe amendment is the accrual date. When would you contend the accrual date for the cause of action would have been here?
Well, I think that the prevailing case law that came out after this case had been filed, specifically the Harris case and the Silver Shells case, would suggest that the recording date becomes the operative sort of starting event from a statute of limitations perspective. And so but however that notwithstanding, I think that ultimately, we need to look at what actions were taken by the association voluntarily in this situation. And I think that looking ahead to 2012,
Well, I just want to make sure I can put a pin in this.
Certainly.
So if we do not accept your argument about the subsequent ratification, the subsequent fix-it vote as being the point of entry for accrual, would you concede your claim to time off?
well, I think as to counts 1 and 2 of the Second Amendment complaint, I think that would be the conclusion. And I think that's what the trial court below ruled. The operative final judgment stemmed from a motion for summary judgment directed at the remaining 5 counts of the complaint, specifically 3 through 8, which are largely essentially, well, not essentially, which are premised on this 2012 vote. And so while perhaps there
But
could be,
again, the trial court here seems to be just looking beyond what it is you're actually, what you're really challenging is whether or not this property is brought into the master declaration, into the overarching community.
absolutely. And I think, I'm sorry.
And it seems like that the operative instrument that brought that was not the subsequent vote, it was the 0406 amendment to the declaration, right?
Well, I think that was the initial intent, certainly. And I think also, as stated on the record, the association's intent then was to, after recognizing that there was a problem with those amendments initially, that was something that they needed to fix. And so they could have taken the path of just simply doing nothing, certainly. What I think is also crucial for this court's consideration is that the 2012 vote was not the only recording in 2012 that we believe is operative or dispositive in this case. It needs to be taken sort of hand in hand with the notice of intent not to enforce, which again, the association also voluntarily recorded. They did so prior to holding the vote to ratify the underlying amendments. And its effect is stated to acknowledge that there are problems with those amendments and to affirmatively state that the association's intent is not to enforce those provisions, specifically because they contravene Florida statute in the unilateral authority that was given to or assumed by the developer and ultimately which gave rise to where we stand today. And so it's to look beyond the 2006 amendment. We're looking not only to the 2012 vote, but also to that 2012 notice of intent not to enforce, which needs to be taken hand in hand with the vote, because the whole purpose, as set forth by the association in doing anything in 2012, was to acknowledge that there were issues with the underlying amendments, to record a document that said we will not enforce them because they are problematic, and then to take a vote to ratify and to essentially correct the
That
issue.
notice of intent doesn't cause any harm to your client, right?
But
I mean, the center of gravity of all this remains those amendments that you also properly, that violated Florida statute. That's the center of gravity of everything, right?
I think ultimately it is, but what we're left with is seeking declaratory relief in essentially fitting those pieces together. Because now you have the 2 amendments that were recorded, we contend improperly, and we believe that the record, and at one point at least, the lower tribunal agreed with that agreement, although that issue flipped back and forth, that the underlying amendments were improperly recorded. And that now we have a subsequent recording by the association, which again was voluntary, this was not under any type of court order or other instruction, where they say, we're not going to enforce this. And so if we look at what appears in the official records as binding on the association as relates to the subject property, now we're left with amendments that were apparently problematic and a recording from the association saying we're not going to do anything about that. And then we record this corrective certificate, so-called, which apparently closes the loop, so to speak, and puts a bow on whatever the procedural or statutory improprieties may have been. And so even if we were to set aside the 2012 vote, we are still left with the 2012 notice of intent not to enforce. And I would agree with you that it does not harm my client in and of itself. However, it would be presumably subject to revocation by the association, which would revert us right back to the underlying amendments and make them, with a wave of a pen, subject to the master association all over.
Isn't that a problem, though, that nobody caught this when they were originally recorded? In theory, anybody could have challenged this that had any standing within the community within the 5 years of the recordation. Anybody could have flagged that, look, this violates Florida statute, you've got a developer retaining the right to unilaterally add lands into the association and all the other things that you all are, the attendant arguments that go along with that.
Sure.
Nobody did.
Understood, understood. And I think ultimately we're looking at the association's intent in taking these actions in 2012. As I mentioned before, they could have simply done nothing. In which case, the 04 and 06 amendments would have remained undisturbed, no one had challenged them, and so no one would have been able to challenge them. But they didn't. They took these affirmative
It
steps.
seems to me that that's the issue that you all are really kind of trying to chew on, is this notion that you could have a declaration hanging out there that is arguably violative of Florida statute in what it purports to do with property, but you don't have a point of entry because the statute of limitations has run since the date of its recordation.
Well, and again, I think to circle back to the earlier point regarding counts 1 and 2 of the second amendment complaint, that is the conclusion that the lower tribunal reached in initially denying or granting summary judgment, I should say, as to those 2 specific counts. The actions taken in 2012 still stand alone as actions that are affirmatively taken by the association,
Well,
which were
but
recorded.
as you just said earlier, that it's the bow, it's tied together, so it's not, you can't look at them by themselves. If you could, you would have a true standalone deck action as to the notice of intent in 2012, so all that stuff, but seems to me it's inextricably linked to ultimately what you really want to go after, which is these statutorily non-compliant amendments that got recorded.
Well, and I'm happy you made that point about the inextricably intertwined or inextricably linked component. I think that ultimately that's sort of the double-edged sword that the homeowner is left trying to navigate here. Either there is a line separating what happened in 2006 and 2012, in which case we're fully within our rights, and I would submit fully timely in attacking that as a standalone vote. Because the vote happened in 2012 and the suit was filed in 2012. I don't think there's any question that that would be considered timely under a 5-year statute of limitations. However, if we flip it back around and say that these are inextricably intertwined, such that what happened in 04 led to what happened in 06, led to what happened in 12, then the process was in fact not completed by the association's own voluntary actions until 2012, in which case that would bring everything under
So
the
the
court's
lines of
purview.
that logic, if they had, suppose they had just simply done a re-recording of the 0406 amendment, I kind of lose track which one is this, is a lot of amendments.
Yes.
But then, you know, just in order to satisfy Martin, they just re-recorded in 2012. Wouldn't you then have a fresh opportunity to challenge that? They didn't do that. They did something totally different. They said, I'm not going to enforce this at all.
Correct. Well, and I think that's where this case becomes slightly distinguishable from the Harris and the Martin cases, in that both of those cases were premised on essentially finished products, if I may. So where these associations have recorded amendments, the homeowner subsequently purchased, the homeowner then at a later date filed suit to challenge those amendments. There was nothing that sort of revived or freshened. There was no new action taken by the association in those cases, such that we are looking backwards at exactly what happened at a fixed point in time. And I think that's where those cases begin to become distinguishable from what's before your honors this morning, in the sense that the association took these steps affirmatively and voluntarily to correct what they admitted to be an issue. And so when they did that, they brought themselves under the purview of 723.061C. They have, those actions would need to be compliant with applicable statutes such as they exist. And so that's where the door is opened to attacking, I would submit, either the standalone vote itself for statutory compliance, or, as your honor mentioned, the entire package, so to speak, where the association is bringing this issue back up and taking an affirmative step to say, this is completing the process. What we did in 04 and 06 was not done. And so now in 2012, we are going to say, this is the step that we will take to close the loop and to essentially ratify what we've done previously. So in conjunction with not only the vote, as I mentioned, they also record this notice of intent not to enforce, which for the time being and in a vacuum would insulate, or would seem to insulate, the Casitas members and owners from mandatory membership within the master association. But then the further step was taken to hold this membership vote, which, if statutorily compliant, I would submit, would close the issue and there would not be a cause of action to be brought. However, and as we get into, this segues into our second argument, which we consider to be really the primary thrust of the issue with the lower tribunal's ruling, that action, that vote still needs to be statutorily compliant. And 723.061C requires that actions or amendments taken which materially and adversely impact the proportionate voting share appertaining to a unit require unanimous approval absent some other express directive contained in the declaration. And as I briefed in our initial before the court, this declaration contains no such express provision that would, quote unquote, otherwise provide for anything but unanimous approval in the situation in which the resulting amendment or the amendment results in a material and adverse impact to the proportionate voting shares of each individual unit owner. And so I think to follow that thread further, what's crucial in this particular situation is that the votes themselves are appertaining to the unit, meaning that each unit owner has one vote by virtue of the fact that they own that property. Now, in this particular case, the association.
Councilor Rich, 5 minutes.
Thank you. If I could just briefly finish this point, the association created a weighted voting system. There are four neighborhoods within the association, and so the goal of the association was to maintain that roughly equal weight across each association. However, that is a creature of contract. That's an arbitrary structure established by the association. It is not appertaining to the unit itself. Each unit owner still has one vote, and so when you go from 250-something units to 350-something units, there is a material adverse impact in the proportionate voting share. Each one vote now is worth proportionately less, which therefore brings us under the purview of 723.061C, and therefore requires unanimous approval of any such vote. And so we would ask that the court reverse and remand, and with that I will reserve the remainder of my time. Thank you.
May it please the court, good morning, Mark Tinker, and at council table is Brandon Tyler on behalf of Caliente Master Association. Obviously, I'd like to start, Judge Lucas, with your questioning about the approval date, because that is very obviously the key for statute of limitations issue here. What the law spells out, and I know council agrees, Harris versus Aberdeen kind of is our blueprint for when the accrual occurs, and there are really two dates depending on the type of action that's being raised. There is the actual recording of the amendments or of whatever it is that is being challenged. I know, Judge LaBrie, you referenced this right at the beginning, is that Florida has a notice recording statute that when the document is recorded in the official records, it becomes notice to the world. So anyone wishing to challenge it has notice. That is the accrual date there. As far as a declaratory judgment action, which is what we're talking about, these counts 3 through 8 that have been the subject of this appeal, a declaratory judgment action, the date of accrual is a date that the claimant first has an interest that is in need of declaration. In this case, this type of situation, it would be Mr. Close's moving in, buying a property at the Caliente, in the Caliente Resort. So as soon as he took title, he now has an interest in saying, these are existing declarations or existing amendments. I don't like them. I want to have my interest declared. He has 5 years from the date he took title. Do these amendments exist? He has notice of them. Now he has an interest. That is the last element of his cause of action.
Is that correct? Here's what troubles me about that notion. First of all, there is some law, and even some more recent law that appears to tie at least reformation actions, which are kind of a cousin of deck action, to date of recordation, not acquiring an interest. And it seems to me that makes sense, because if you have, you could, people could be buying and selling in these properties. I don't know what kind of turnover they have on these, but they could, in theory, you could have a situation where, 15, 16, 17 years down the road, somebody acquires, a lot, and, I just now noticed this for the first time that this declaration back here has some kind of problem, what have you. I'm going to challenge it. You would never really have a statute of limitation, really, on any recorded instrument.
I think the key to that is because it is a declaratory action, and if you look at these specific counts, you look at the relief being requested in all of them, it's being asked to get rid of these amendments, to construe these amendments, to render them void, invalid, various, different phrases are used throughout those 5 counts. But the key is that is the harm that's being declared, and, Mr. Hannon said just a few minutes ago, he said this amendment, this vote that happened later on did not harm his client. It was the original amendments that caused the harm. So when does the harm become right for him to do something about it? I think it has to be the date that he took title. And I know you're saying, well, that could just lead to a bunch of different actions, even 15, 20 years down the road. To a certain extent, I think it has to be that way because you could have, there's associations out there right now that are passing laws that maybe violate a statute somewhere, not laws, passing amendments that violate a statute somewhere. None of us care about that until we all of a sudden go buy a property there and look and say, this isn't proper, I would like my rights declared, I live here now, I have an interest, I would like somebody to take a look at this. And
Isn't that the whole purpose of recording the deck in the first instance? So that you know what you're buying?
All the stuff gets disclosed to potential buyers, right? I mean,
Yes. And and that is why, as far as the counts 1 and 2, Judge Mansfield said you cannot render these amendments invalid. You can't go back and try to void them. You're too late because you had notice when, there was notice to the world when they were originally recorded. But as far as just having a declaratory judgment action filed to say, what are my rights now that these amendments do exist, then that would have a new statute of limitations that arises from the date that he moved or purchased the property and gained an interest in what those amendments do to his property that he owns now. So I think that is the key as far as when this accrued is his taking title to the property. And there's one thing that I do want to address because I want to make sure the record is clear on this. When I was looking through, full disclosure, I wasn't primarily responsible for briefing this case. I was preparing for the oral argument, and I'm looking at the initial brief and looking at the order that we're here in appeal. And the order itself says that Mr. Close took title to the property, references November of 2007. And the initial brief references that date as well. And of course, that would be within 5 years of the September 2012 filing of this lawsuit. So that kind of raised a red flag to me, and I looked at it. And I believe that there's a typo in the judge's order because that November 2007 date, that is the only place in this 12-year history that date ever appears anywhere in the record. If you look at the actual complaint, the Second Amendment complaint is the operative pleading that was filed. Mr. Close says, I bought the property in March of that year. He attaches to the complaint a copy of his file stamp deed that shows that he took title to the property in March of that year. He filed an affidavit later in the proceedings that said, I took title in March of that year, and attaches his title again. It was admitted in the answer to the complaint, so it's been an admitted fact. So all the way through, it has been an established fact. I think the judge has put a typo in the order, and then that was cited in the brief. I'm sure it wasn't intentional.
But it's like special accrual from the original enactment, it doesn't even matter, right?
Correct. That scared me when I saw it, so I wanted to make sure the record was clear on it, that it has been undisputed throughout the 12-year history of this litigation that he took title well over 5 years before the lawsuit was filed. And I mean, I think that is the only questions that the court has had has really been about the accrual. I know counsel touched on the vote. There were no questions. I'm happy to rely on the briefs on that issue unless the court has any specific questions for me on that. Otherwise, I just ask that you affirm. Thank you.
Thank you, Mr. Taylor. Response? We have about 4 minutes left. So.
Thank you. Thank you, Judge. And I think, just very briefly, there was one comment that counsel made regarding the, essentially when the harm, so to speak, starts. I made the comment, I believe, that the notice of intent in and of itself is not harmful. However, the vote that occurred in 2012 is what, by the association's admission, serves to impose, ratify, and bring the subject property under the purview of the master association. So that would be the accrual, essentially. That would be the last component of an action targeted against that 2012 vote. So I just wanted to clarify that.
How does the trial judge's characterization of the 2000 6, 7, I've lost track of days, but that one being voidable, not void, how does that affect your position, as you just stated?
Well, I think it's what gives rise to this statute of limitations defense, that if it were void in and of itself, excuse me, that we would be faced with a very different result. The fact that the court concluded that it was merely voidable and subject to a statute of limitations defense, meaning that it would need to have been challenged within 5 years of recording, I think is why certainly we're here today and why the trial court ultimately, or initially, I should say, granted summary judgment in favor of the association as to those first 2 counts. And I think that's important to keep in mind for this court's consideration today, is that we're talking about essentially a divergence in analysis with this final judgment, looking at counts 3 through 8 and the impact that the association's actions in 2012 had upon the subject property, and whether that subject property ultimately is subject to the purview and the control, excuse me, so to speak, of the master association. And so essentially, I think from the appellant's perspective, what I think we're left with looking at is essentially that there's this idea that the association is asking the court now not really to look at what happened in 2012 at all, and just say 2006 is the trigger date, statute of limitations runs in 2011. It doesn't matter what happens thereafter. It doesn't even matter if we do anything thereafter. But that's what makes this case distinguishable from the Harris case, from the St. Martin case, because the association took it upon itself to take those steps voluntarily and affirmatively to say, there is a problem that needs to be rectified. This is how we're going to do it. And in so doing, we are going to record a document that says we will not enforce those problematic provisions because we recognize that they are contrary to Florida statute. And so the fix to all of this is to hold a vote, and with the stated intent being to ratify the underlying 04 and 06 amendments by extension. And in taking that step, the association we submit is beholden to applicable Florida statute, most specifically 723.061C, which would require unanimous approval of that vote for the express fact that the upshot of that vote is to proportionally, materially, and adversely diminish the voting right opportunity to each unit owner. And so when that is what's on the table and that is what is at stake, the statute requires unanimous approval. The association contends that the 2/3 majority was reached. We submit, and as briefed, I'll just very briefly touch on that, that the association did not reach a 2/3 majority, that a review of the votes as attested to in Mr. Klaus's affidavit before the trial court and provided as evidence for summary judgment, that there was some question as to whether the association even reached a 2/3 majority, if in fact that is the standard that the court sees fit to impose, as opposed to unanimity, excuse me. And so ultimately, I think, again, to close up on this statute of limitations argument, I think that because of the actions taken by the association in 2012, we cannot either draw a line that completely severs what came before and what happened in 2012. And conversely, if they are deemed to be inextricably intertwined, as the LE has stated, that final step, that final action taken in 2012 brings everything onto the table and does provide a challenge against the prospective effect and intent of what happened with that 2012 vote, such that if the court should find that unanimity of approval is required, that vote failed, and that those amendments therefore were not ratified. By extension, if those amendments are deemed to be protected by the statute of limitations, there's still the question of this notice of intent not to enforce, by which the association has bound itself not to enforce those provisions. And the upshot of those provisions at issue would be creating a mandatory membership of the subject property in the master association. So with that, I thank you all for your time, unless there are any further questions.
So it's a good place to wrap up. Thank you very much. Well argued, both sides.
Thank you, Judge.
cases are somewhat intertwined, but I'm going to read before 20 minutes on each. Just treat them as two separate cases. This case has got enough going on. We're going to have plenty to talk about.
Thank you.
Acceptable, everybody?
Yes, sure, thank you.
Okay.
Yes, sure.
Okay, Ms. Berman?
Thank you, Your Honor.
Good morning. May it please the court, my name is Stacey Berman, here today on behalf of Berkeley Insurance Company, the appellant in this case. If I may, Your Honor, I'd like to reserve 4 minutes of my time.
Fine.
Thank you. As the court is aware, we've got 2 issues here in this merits appeal stemming from 4 different causes of action. We've got 2 causes of action disposed of at the dismissal stage on motion to dismiss, and then 2 causes of action disposed of at the summary judgment stage. So I'll just start, if I may, chronologically, and we'll go back to the beginning to the motion to dismiss stage. But we had counts for tortious interference against the bank and for civil conspiracy. Now, the ultimate dismissal was because of allegedly, or the finding was that Berkeley did not state a claim for tortious interference. And the only element of tortious interference at issue in terms of whether Berkeley stated a cause of action is whether Berkeley sufficiently alleged that the bank intentionally and unjustifiably interfered with the contractual relationship between Berkeley and Tempo here. Now, the trial court seemed to think, if you take a look at the order, which is at the record, page 1997, that a non-stranger to a contract, which is exactly what the bank is here, can never be liable for tortious interference. The trial court doesn't cite to any law to the contrary, says Berkeley didn't argue to the contrary, which is in fact not the case.
So you're relying on the allegations of the Second Amendment complaint?
Yes, Your Honor.
Can you sort of direct us specifically what you think your strongest argument is
Allegations.
based on those various allegations that are contained? I think they letter A through U or A through B, there's quite a number of them.
Absolutely, there's a number of them. This is a very, very robust complaint, and I will touch on those and simply tell you that it's far more robust than any case that's been cited to this court where a dismissal has always been reversed in this type of situation. Our allegations include everything from, if you take a look at paragraph 38 of the complaint, it was always the bank's plan to, with illicit motive and through improper means of control over Tempo, unjustifiably withhold as much as they could of the contract sum, despite Tempo's promise that it would pay Berkeley. The complaint goes on to allege that the bank conspired with Besselo to terminate the GC through, quote, any means and methods available through words to the effect that Besselo should do anything it could to default and terminate the contract. There's also an allegation of secret communications with another contractor in anticipation of breaching the contract weeks before the termination. Paragraph 1 of the Second Amendment complaint, the bank caused Tempo not to pay and to terminate the contract without following the contract terms for non-payment or termination, thus causing a breach of the contract. Another allegation in paragraph 27 of the Second Amendment complaint, there are extensive allegations about the roadblocks being thrown in Berkeley's way, culminating in an allegation at paragraph 38 that it was, quote, always the plan to unjustifiably withhold as much as they could of the contract sum. Paragraph 52, there are more allegations about planning the contract's termination weeks ahead of time, meeting with other contractors, negotiating fees with Besselo. All of those things would be encouraging a breach of contract, which even...
Ms. Berman, here's, and I've read the complaint through, and
Yes.
and I think your characterization of it being, forget the word you used.
Robust.
Robust, is not inapt. Here's my concern, and maybe you can help me with this, and I'll need to tie this to the order as well, that has definitely been touched on on Brian's briefs on the other side. What I read here seems to me like you have put into a tortious interference and civil conspiracy framework what sounds a lot like piercing the corporate veil. Because as you all point out repeatedly, the bank is a 99.9% owner of the LP. they're the ones that are pulling the strings. But ultimately, Berkeley as the surety and the original contractor knows this going in, right? I mean, they're doing a contract with an LP that is completely controlled by Bank of America, but they are not in a contract, at least as obligees of the surety, but they're not in direct privity with the bank itself. And everything here seems to be saying is, look at all the bad things the bank did while they were acting as the controlling interest of the LP, which is in essence a piercing the corporate veil argument. So help me out here, because my concern is that a good lawyer putting together a complaint, a civil complaint like this, can get around all the pleading requirements of a piercing the corporate veil cause of action, which has its own separate heightened requirements to plead and prove, simply by casting it all as a tortious interference or civil conspiracy claim. Help me out with that.
So in short, Your Honor, it's definitely not piercing the corporate veil. First of all, ultimately, the bank has that level of ownership. It did not from the outset. So, which, we're going back to the beginning when you mentioned what the situation was when you entered into the contract. Second of all, I think the bank would be the first to tell you that it does not consider itself, that this would not be, I don't think the piercing the corporate veil went to this particular argument, because I do not think that the bank is making it very clear that it does not think that it is these entities or, controlling these entities. It has done everything to say that it did not control these things, that it did not cause these actions, that it did not pull these strings. Those are Berkeley's allegations, which we think are correct and true, but the bank has disputed those. So I don't think that's the case. And in any event, Your Honor, at the end of the day, they are not a party to the contract, the construction, the contract here. They're not. Now, do they have an interest in it?
This deal is structured so that they're not.
Correct, absolutely. And so do they have a financial interest in it? Yes, they do. Do they have an economic interest that they have a right to some extent to interfere with the contract and protect? Yes, they do.
Well, my concern is that this scenario happens all the time. Single purpose entities get set up for the express purpose of keeping certain players out of contractual privity, but they're still going to be calling the shots. And it's up to everybody that's negotiating the deals to understand who's calling the shots, who's got the money behind it, who's calling the shots, who's directing who, and ultimately, are we satisfied that we've got sufficient privity and sufficient recourse against the people that we are in privity with, that we'll go forward with the deal or not. And my concern, when I'm reading through these, everything that you're talking about is look at the bad things the bank did while it was directing Tempo. But it had that power. I mean, it could do that. That was the deal that got set up, unless we just go right past the LP, put it aside, and go straight to the people that were pulling the strings here, which was the bank.
I don't disagree that there are contracts structured like this all the time, which is why the law allows for someone like the bank to interfere with this type of contract. Typically, right? Going back to tortious interference for a moment, the elements of tortious interference. It's about who can interfere. One of the allegations is, can you interfere with this contract? And everything you've just talked about, an entity like the bank could and would be able to do so typically. Berkeley's not disputing that. But there is a limit to that. You cannot be behind the scenes and pull the strings so hard to a point where your interference with the contract is then resulting in the breach of that contract, for instance. That's what Florida law draws the line.
Argument in response to what friend on the other side has made. Berkeley alleged in paragraph 79, A through Z, and all the other paragraphs that you rattled off. There's certainly, we all agree, I think, that there's a robust collection of allegations. But fundamentally, Berkeley alleged sufficiently the malice and self-dealing type conduct to take this out of the otherwise generalized privilege. Is that
correct? Yes, that is absolutely the nut of it. And at the end of the day, Your Honor, and to answer your question, Judge Lucas, we are here at a motion to dismiss. So if we're going to talk about who was pulling the strings and who knew what and what was what, that's exactly, by the way, why this would not be dismissed. This was not dismissed due to anything related to piercing the corporate veil. Those weren't the arguments at issue. This was simply a, hey, the trial court says you can't state a claim for tortious interference against a non-stranger to a contract. That's not correct under Florida law.
Can I ask you to focus before we use up all your time, on the quasi-contract claims?
Absolutely, Your Honor.
And my first question for you is, your opponent has argued that Berkeley can't recover here because it has a direct remedy on the Tempo contract. And I understand your argument based on Agri-Trade and similar, that that's fine, that the bank isn't a party to that contract. However, I think we still need to confront that Berkeley has a direct legal remedy against Tempo in this legal realm. I think that's a consideration. Could you address that, please?
And so is your concern, trying to get to what your concern would be, Your Honor, is it a concern about double recovery, for instance, or just the fact that Berkeley has
No,
that?
I get that you can, at the pleading stage and up through summary judgment, certainly Berkeley can plead alternate theories that would eventually not be permissible as double recovery. But no, that's not really my question. My question is that Berkeley does have a direct contractual remedy against Tempo. And that's a factor that's considered in some of the analyses of the cases that you all have cited. So we've got this very close contractual relationship. I'm not sure what the argument would be on the rider bringing Berkeley into, bringing Bank of America into the direct contract with Tempo, but there's an argument there. And so really just trying to get to the guts of what I think is the problem on appeal with the equitable claims. You know, it would be easy if there was a direct contract, or if Bank of America had just showed up one day after it made the loan and started directing the architect and whatever. But there's such a close relationship, and fundamentally the deal is, Tempo contracts with its GC to build the thing, you guys bond it, and the bank funds it. At the end of the day, the surety's remedy is typically against the owner. And that's what you have here, only I think Berkeley's been very creative and very aggressive in trying to work around that in this situation. But the fact remains that at the outset, your contract is with Tempo, and everything that's gone wrong here should be redressable in that context.
In theory, although, Your Honor, summary judgment is premature because in other litigation, as noted in this record, Tempo has denied that Berkeley's claims are actionable under the contract. Tempo says that this is not a breach of contract action against it. And so arguably, if that were correct, there's no contractual remedy available to Berkeley. In fact, to get to this point, it is not clear, in theory, Berkeley does think it has a breach of contract claim against Tempo, to be clear. But Tempo says it does not. And if that were the case, then Berkeley would certainly have other avenues. But be that as it may, you can absolutely, just because there's a contract between Tempo and Berkeley, does not mean, Your Honor, that you cannot sue someone else.
Understood.
Right, for unjust enrichment. And I'm not aware of any cases cited in the cases I know of that deal with these issues would be the commercial repairs case, the Variety Children's case, Wilson, FH Passion. I'm not aware of any of those cases that would prevent an unjust enrichment claim in this particular situation simply because there is an express contract that exists.
What about the rider? Does that change anything?
How so, Your Honor?
The rider that makes the bank an obligee under the bond
Right.
and incorporates the bond to the record language. So there's an argument that now the bank is a party to the bond because it's an obligee and that contract has been incorporated.
And so you're saying that there would be a breach of contract action against the bank?
Well, at least as a starting point, the bank is now a party, a direct party to the bond because it's an obligee of like status as Tempo.
Right, well, yes, although the rider is there to protect the bank and to be sure the bank has certainly not made that particular argument, so that would not.
In fact, the declaratory judgment that I think was stipulated to
Correct.
basically disavows that. But just looking at the rider itself, that it creates a question. Let me ask you I had two questions for you on this. My other question goes to the direct benefit. As I understand your argument, putting some of the clutter aside on the benefits and not getting down the weeds of agri-trade and the Judge Davis's opinion and who shot John and all of those, reduced to simple terms, even if you put all that to the side, you're arguing that the tax credits and reputational credit was a separate benefit that Berkeley conferred to the bank. Am I right?
You are, although I will tell you that this is an interesting question about the benefits. Yes, I do think it's a separate benefit. I don't think it matters, by the way, though, whether it is or isn't a separate benefit. I think that under Florida law, it does not require a benefit to flow. It can flow through someone else under Florida law, which is one of the points the bank has made. It says that all the benefits that Berkeley conferred on the bank flowed through Tempo. That is okay under Florida law. The only cases that say it's not okay are cases involving suing a principal or a shareholder about benefits that a corporation received. But in any event, without a doubt, things like reduction of BACDC's obligations to pay excess development costs, the business reputation issue, the savings of the $40 million to the bank, those are direct, and separate
And what
benefits.
do we do with the trial court's order that sets forth the testimony? I think it's Bank of America.
It's Nancy Mano saying that the benefits are the same.
The same.
Right, and I would say, so what, to be frank? It doesn't matter whether the benefits are the same. The trial court found that it matters, that they are the same, and therefore that's a problem. The bank says in its answer brief that it's not a same versus different benefit issue anyway, it's a direct versus indirect benefit issue. So there's that. We address the same versus separate issue because the trial court order used the word same. And we have given many instances of different benefits to the extent that anyone believes it matters, whether it's the same or a different benefit. We would suggest to you that this is sort of all semantics because at the end of the day, same, different, kind of lines up with direct versus indirect, and certainly Berkeley agrees that the benefits do need to be direct. So the question is simply, what's a direct benefit? And we would tell you that these are direct benefits. There is no case law to suggest that they are not. And by the way, all this benefits discussion and this aspect of summary judgment only goes to the unjust enrichment claim. Only unjust enrichment requires a benefit conferral, not quantum merit. So at the end of the day, I don't think it matters that the trial court said that, but I think that we have provided plenty of evidence anyway, that there's a different benefit in case that does matter, and that these benefits are direct. So.
Jumping back to your tortious interference argument, your opponent in their answer brief argues that the limited exception malice, the gone too far exception, must be alleged as an element of the main claim. And they contend that your allegations don't satisfy that. I think we've been through. But just from a pleading standpoint, I was unable to find a case that says that exception must be alleged as part of the main claim.
No, I could not find one either, Your Honor. I do not think there's a case law out there that says that.
Very good breaking point for you.
Thank you, Your Honor. I'll reserve that time.
Good morning. My name is Stacy Blank. I'm here today on behalf of Bank of America and the Bank of America Community Development Corporation, who are the appellees in this first appeal. For convenience, I intend to refer to both of them as the bank unless it becomes important that we distinguish between them. Although Berkeley has maintained throughout this appeal that the construction dispute giving rise to the appeal is terribly complicated, the issues in this appeal are actually quite simple and straightforward. The bank sued Berkeley sued the bank for tortious interference, civil conspiracy, unjust enrichment, and quantum merit. The trial court applied well-established Florida law to reach an entirely predictable result in this case. Now, I heard for the first time today that Berkeley would agree that it had an obligation to plead unjustified interference with the contract between Berkeley, or the business relationship between Berkeley and Tempo, and that a stranger to the relationship is an element of that pleading requirement. Doesn't take long to read through the complaint to realize that the bank is no stranger to this relationship, even if you look no further than the four corners of the complaint. So now it seems like where the argument has evolved is that we are now left with the exception to the unjustified enrichment, and that is where malice is solely the purpose for the interference, or whether the means that are used are improper. Here what we have are allegations that say that the bank took action to protect its own interests, but it didn't do it using any means that were prohibited to it under the agreement. And in fact, the trial court found these are exactly the sorts of things that lenders do to protect their interests in the collateral. And so clearly there's no allegation, I don't think that my colleague.
Berkeley alleged, plainly and repetitively, that many of the actions the bank took were designed to protect the bank's interest and were based on ulterior motives and not taken for the benefit of Tempo. That comes through loud and clear in the allegations of the second amendment complaint.
But there's nothing wrong with that. I mean, there's absolutely nothing wrong with the bank protecting its financial interest as the lender in the project.
Of course, but doing so based on ulterior motives.
Well, having a bad motive is not enough. It has to be solely through malice, or it has to be an improper means. Here, there's no improper means, and there's no sole motive of malice.
Motive is usually a fact issue, right?
Well, it typically is, but here, I mean, the allegations are all on the face of the complaint. And so I think the court was well within its authority on a motion to dismiss to say, if I accept as true all of the allegations of your complaint, you still haven't alleged what you need to allege.
Well, for example, and I think this is threaded through the complaint, colluding with or controlling the owner in such a way as to prevent Berkeley from being paid. Isn't that improper?
If it has the power under the contracts, as the court says it did, that's not improper. All it's doing is exercising its contractual right.
Of their allegations and your position on them. Your position boils down to the bank was privileged. And that, the cases say, and I don't think there's any discrepancy across the case law that we've studied so far, that is a fact question.
So, I mean, it's an interesting issue. So I think it's a burden shifting issue. I think clearly a plea requirement for Berkeley to prove unjustified interference. And to the extent that it's trying to say we are pleading an exception to the unjustified interference requirement, that's a pleading requirement. And then if they
you don't cite a case for that, and we're not able to find one. So that's based on your pragmatic view of the case law as it stands today.
Well, and the case law says that, an element of the cause of action is unjustified interference. And so that is a pleading requirement.
And they've alleged
Yeah.
unjustified interference without question.
And so then I think, and there is one case that's cited in the brief that talks about then once unjustified interference has been alleged, the burden then shifts to the defendant to say, okay, even though I'm a stranger to the relationship and my interference would not as a matter of law be justified, I'm nonetheless privileged to interfere because I do have some relationship or some ability to protect my own business interests. And an example of this would be in the employment context. So an employer has an employment relationship with the employee. New employer wants to hire some folks. And they they hire a headhunter, they run ads in the paper or on the internet, whatever folks do anymore, to hire people. And essentially the way that it works in that case is so long as employer number 2 does not induce the employee to breach a non-compete that the new employer knows about, the employer, new employer, is privileged to solicit that employee. And that is privileged conduct, and you can see it all in the cases, that that's not tortious interference with the original employment relationship, even though the new employer is a stranger to it. So that's where the privilege arises, when you have someone who is not a stranger, who actually is a stranger to the relationship, but the behavior is nonetheless privileged. And so I don't think that the privilege that we're talking about here is an affirmative defense. That's a fact issue. I think it's a pleading issue. And then the question is whether, taking the allegations of the complaint, they have pleaded sufficiently. And again, solely malice, not just, some mixed motive, solely malice, or an improper means. Not again an improper motive, an improper means. Have they engaged in some conduct? Have they induced, someone to breach a contract when they do not have the authority under the contracts themselves to have input in that decision? I want to talk for a minute too, and I guess it's an obvious point of what I was saying, but even if the privilege defense is an affirmative defense, the Florida law is clear that the court was permitted to consider the defense if the facts all appear on the face of the complaint. And so it's really a distinction without a difference here. Talk a moment about the unjust enrichment and the quantum merit claims. We could talk about the direct benefit. It's pretty clear after the Koppel decision of the Florida Supreme Court that Florida law requires a direct benefit. That benefit cannot flow through an intermediary. So to the extent that, the use of the word same when the court was talking about the same benefit, essentially the court was focusing on the fact that the improvements to the real property that Berkeley accomplished was the benefit. That is the benefit that they've identified all along, and they've said that Tempo, the bank, everyone involved was benefited by the fact that they made improvements to the real property for which Berkeley was not paid. And so the trial court, I think appropriately, concluded that those benefits flowed through Tempo. Tempo was the owner of the project, notwithstanding Berkeley's half-hearted attempts to say that the bank was actually the owner, and sometimes actual attempts to say the bank was the owner. The bank was not the owner of the property. And so to the extent that the benefits flowed through Tempo to the bank as the lender, to other investors, to shareholders, to officers and directors, to employees, those people are not on the hook for Tempo's contractual obligations.
What about the tax credits?
So the tax credits are interesting. That that was an 11th hour shift in position, and I think the trial court said, look, you can't in summary judgment.
Sometimes the best stuff comes at you.
Well, I know. It never fails, right? Essentially, the court said you can't change your position now about what the benefit was. I mean, you alleged what the benefit was, your corporate representative testified about what the benefit was, and now to defeat summary judgment, you come up with a new benefit, and that's too late. But even if you did talk about it, those benefits flowed through Tempo too. I mean, the tax credits came about through Tempo, the owner of the project. And so I don't really think that does much to salvage the claim. And, it's interesting, to reach any other conclusion would really be nonsensical. I mean, the law in Florida cannot be that anyone who receives money from a corporation is nonetheless on the hook, for that corporation's contractual benefits simply because it received a dividend or it received a loan repayment.
Yeah, money moves real quick in our system.
It does.
Yeah.
Now I want to talk for a moment about the presence of the express contract. And so we filed a notice of supplemental authority yesterday with a new case out of the 3rd DCA that was issued after our briefing. And the court explains agri-trade and essentially makes the argument that the bank has made here. And that is, you do not have to have absolute identity in the parties to the lawsuit and the parties to the contract. So long as the plaintiff has a legal remedy against a party to the contract, that plaintiff cannot seek to recover in quasi-contract from somebody who's not a party to the contract, so long as it's about the same subject matter. I mean, of course, it could be something different. So here, this is exactly the situation that we have. The court in Nichols, the name of the new case, explains that the existence of a valid legal remedy against one party, which is here Tempo, the breach of contract action against Tempo, will bar a quasi-contract claim against another party, including one who's not a party to the contract, which is here the bank. And so the presence of the express contract gives Berkeley a remedy, it gives Berkeley a legal remedy, and it bars the quasi-contract claim against the bank.
So does that mean that you win on the summary judgment?
I'm sorry?
The summary judgment, in your view, that's the justification for why it was granted?
I think that's right, is that
That's
it's,
the right result.
I do think it's the right result. I think it's the right result, and I mean, particularly in a case like this where the contract includes very specific limitations on Berkeley's ability to recover under the contract. If the court were to permit a quasi-contract action for that same obligation, it would have none of those contractual limitations. And so,
Reduced to simple terms, your point on Peoples is it sufficiently distinguishes agri-trade in a way that neutralizes whatever the loose ends were in Berkeley's argument or yours, depending on perspective.
I think that's right.
The explanation, and notwithstanding Judge Booker's concurrence, pretty much ties that up and using her metaphor, puts the bow, or I think your predecessor's metaphor, puts the bow on top of.
I think that's right, and it just,
Something.
right. It clarifies that the only party that has to be a party to the contract is the plaintiff.
And then if there is a legal remedy against the same subject matter, blah, 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 right?
Yes.
Does the new summary judgment statute figure into this?
I'm sorry?
The new summary judgment, does that figure into the calculation?
Well, I don't think so. I don't think that the appellant has challenged the court's application of the new statute. Now, the court revisited its decision. It originally denied summary judgment under the old standard. And after the adoption of the new standard, the bank filed a renewed motion and the court granted it under the new standard. And so I can't say that it had no bearing, but I don't think it has bearing on this appeal because no one's challenged the propriety of that decision, or for that reason. I thank you for your attention.
Your Honors, I have just a few points, and I'll sort of work in reverse order. Starting with we just talked for a minute about the Peoples case and whether that resolves the agri-trade issue. Actually, it does not. Just to put it bluntly, I think the 3rd DCA just has it wrong. Every other DCA in the state of Florida and the Middle District of Florida disagrees with that. It's just a false distinction, this notion that it matters what side of the V in the unjust enrichment claim you're on, in terms of whether you're also a party to the contract. Agri-trade simply says if you're both parties to the contract, you can't have an unjust enrichment claim. You can't have an unjust enrichment claim if you're not both parties. It doesn't talk about who, in the unjust enrichment claim is the plaintiff or the defendant, and whether they're a party to the contract. And multiple cases allow the plaintiff in a quasi-contract claim to sue where the plaintiff is one of the contracting parties. The Shands case out of the 1st DCA, the Henry and Butler case out of this DCA.
I think the difficulty analytically is that, and this is kind of old form of commercial litigation law, is that once you prove the existence of a contract dealing with a transaction, the equitable remedy of an unjust enrichment has to go by the wayside because presumably the parties memorialized all the understandings and all the benefits that were going to flow to whom in the instrument.
If they were all parties to that contract.
Right.
Which they're not here. So, and which is why Williams on the 5th DCA, the commercial repair case, Variety Children's out of the 3rd DCA doesn't agree with Peebles, and yet Peebles mentions none of these cases, including its own Variety Children's case, creating, it looks like a bit of inter-district conflict they've got going on. So the Peebles case is problematic, to put it mildly. Back to direct benefits, the bank says they cannot flow through an intermediary. That is just flat not the case. The LLC case on the 5th DCA specifically says it can flow through an intermediary. We've also got the State Farm case that says that Florida law does not require a direct benefit to flow to a defendant in order to be.
Do any of those cases address the issue where the recipient of the flow-through benefit has a controlling ownership interest of the defendant?
I don't think so, Your Honor. I don't think so. That's the short answer. I don't think so. I think we could talk about that a little more, and then I could get kind of down a rabbit hole with you on what the ownership issues are in this particular case, which all goes part and parcel to why this all needed to be developed a bit more, and why I do not think, again, I think.
You're saying the ownership issue has to be developed more factually?
I think you're asking me too about piercing the corporate veil on tortious interference. And I think, my impression, based on the briefing and all the arguments in the trial court, is the bank would never suggest in a million years that it is acting in a position of ownership whereby there would ever be a situation with corporate veil.
Loosely, and control.
Okay.
Because an LP is made up of its partners, and the partners have to exercise control.
But I think that matters, because the only benefits cases that allow that don't allow the unjust enrichment claim have that very clear, very precise, not just control, but ownership issue where you've got a shareholder or a principal to a corporation. There are no cases that I'm aware of, and none that I'm aware of cited by the bank, that have what you're talking about and what we're talking about here is Berkeley, this control issue. But, and again, and even if we set that aside, I think anyway, there are separate benefits. I'm just making that point for you. But I do think that we could accept this premise and there would still be what the bank would define as direct benefits. Finally, turning back to tortious interference, the bank just mentioned that the face of the complaint shows there's no allegations of unjustifiable interference. I think the court is aware that that is incorrect. However, even if we just look at those allegations, if a non-stranger like the bank is here encourages breach of contract, which is not something that was just mentioned, but there's case law that says that's one of the things, that's where you can go beyond the limits of your privilege to interfere as a non-stranger. That's just Florida law on that point. There is no doubt that Berkeley has alleged that the bank encouraged a breach of contract and then then we have a dismissal of the claim. There is not a single case out there that upholds a dismissal in this type of situation. And this, again, as far as I'm aware, every dismissal case cited to this court is a reversal in a case like this. I have not found any affirmances whatsoever. And finally, Your Honor, I did want to go back because we got away from it and I was a little concerned if you had any more questions related to that piercing of the corporate veil issue, because I do not think it is at all the same thing. I think there's a reason it's not briefed like that in the trial court and it's not briefed like that here. I don't think.
Well, the other side did bring that up. They brought it up in their answer brief.
On the dismissal for the tortious interference?
I can't remember exactly what page or what issue,
Okay.
but I do remember that it was at least suggested that what's really going on here is or an alter ego.
I thought,
It's kind of basically the same.
and I'm like you, I could be wrong. I thought that was in response to the summary judgment issues on the quasi-contract claims, but perhaps I'm wrong. I did not think that that was raised on the motion to dismiss. I don't think so, and I think that that matters. Because I think we would have fleshed this out quite a bit more, because I do not think this is at all like piercing the corporate veil, and I think we would have case law and lots of things to talk about. And again, the fact that we're having this big debate, by the way, I think illustrates exactly why this case should not have been dismissed at the stage it was at. It just shouldn't have been. It was premature. And whether we call it an affirmative defense or not, the privilege to interfere, we've argued that it is. I think it is. I think it doesn't matter. Even if we accept the bank's argument that it's not an affirmative defense, it's still a fact issue that we didn't get resolved. So for all of these reasons, I think this court should reverse and remand on both the order of dismissal and the summary judgment order, and send back down to have those claims go forward. Are there any other questions I can answer for the court? All right, thank you.
Moving right along, Jim. That was so much fun, let's do it again.
I'm still Stacy Blaine. I'm still here on behalf of the bank and Bank of America Community Development.
Let me cut to the chase. So
Before you start, can I reserve 5 minutes of my time for rebuttal? Thank you.
Sorry, Ms. White.
Sorry, Jerry.
assume for the purposes of this discussion that we might find a ground to reverse at least something in the merits judgment. What do we do procedurally with this case? Do we abate it, relinquish jurisdiction, hold it in abeyance without relinquishing jurisdiction? Do we dismiss it as moot?
Well, I think I have to say it depends on what you do. Because I think that the issue is not moot, so long as there's something that's still, a judgment in favor of.
Part of the reason I leapfrog to the end of this is I think the argument, you've both done a great job of briefing your respective positions on, is it all about money, et cetera. And I could ask a lot of questions about those things to sort of flesh them out, but at the end of the day, what we do in the merits appeal, if we affirm, obviously we have to confront the merits of the propriety of the trial court's ruling on the proposal for settlement. But if we disagree with you on a complete affirmance, we do have a little bit of a quandary from a procedural standpoint as to what to do with this case, because I don't think we can decide it on the merits.
I think it depends on what you do. Because if Bank of America retains some victory, then it's possible the court will be able to reach the conclusion that it was a party who secured a judgment and it beat the offer of judgments.
Well, just assume, let's say Bank of America gets to go back and defend all of these claims.
Then that's a different scenario. But I guess that's why I qualified it by saying if Bank of America retains some.
I don't think I understand the distinction.
So let's say you don't
send
reverse
back
on everything.
If we send back half of the claims, right?
Right. Then.
What difference does it make?
Well, it depends on what their judgment ultimately is. But the question before this court is not then whether you beat the offer, but it's just in any subsequent proceeding, can you ever have a claim for fees under the offer of judgment statute because there was a declaratory judgment?
And again, I'm sorry to jump around with you, but moving to the costs, your counsel's already Berkeley's counsel has argued pretty persuasively that that's waived. And the reason being that, you move for fees and costs, you go to a hearing, the transcript of the hearing, the word cost is not uttered. The order on the motion, the only place that cost is in there is in the title, and that's because it carries over the motion. I think that this order issued before the rule was amended to require a 1.53 motion in this circumstance, but Pensacola Beach and the other cases like it are pretty clear that when you have a judgment that you're treating it as final, I understand why, but on the face of it, there's a deficiency, there's no ruling on the costs. There's no denial of the cost motion.
So I disagree with that. I mean, the court denied the motion in total. Now, we did explain all of the grounds for the denial. And if every time a court denies a motion in total, but does not specifically explain that the court is denying every ground and mentioning it, I mean, we are going to have a lot of rehearing motions, and I do not think that's what the rule requires. Here, the order denied, it was a single motion for cost under 5741, as well as under the offer of judgment statute, and the court denied the motion in its entirety.
So you're going to hang your hat, I think entirely on paragraph 1 of that order that says motion is denied.
Correct.
Okay.
Correct. And then the question becomes, okay, is that never going to be enough anymore? Is every trial court now going to say, it's not enough for me to say the motion is denied. I then have to go through every argument that was made to me and explain this one's denied, this one's also denied, this one's also denied, even though I've denied the entire motion. So I think that that's where, that's what the preservation argument is about. And I don't think I do not think it was a requirement to file a rehearing motion to go in and ask the court. Just wanted to confirm, even though you denied the motion, you meant to deny it on every ground.
I mean, this isn't a subjective analysis like the validity of the proposal for settlement. This is a statutory mandate.
But only if you don't have a ruling. But here we have a ruling. We just don't have an explanation. And so I don't think there was a statutory mandate to file a motion for rehearing because I think we had the ruling. So to go back and talk just briefly about the declaratory judgment action and the effect that it has on this case. It's interesting to me because, I think at the outset, the trial court lacked subject matter jurisdiction to hear the declaratory judgment action. There was no live controversy. The court noted it in its order.
That's not a want of subject matter jurisdiction. That's just, there's no cause of action.
It is subject matter jurisdiction.
It shouldn't be.
I'd say that about a lot of things in the law, but in fact, if there is no actual or live controversy, then the court lacks subject matter jurisdiction to enter.
You have entities that are both based in Florida. There is a request for a declaration. Whether or not the declaration is right, moot, what have you, is something for the court to consider. But it can't get there without taking subject matter jurisdiction of the case to decide it. Right?
Well, I mean, courts always have jurisdiction to decide whether or not they have jurisdiction,
Yeah.
but
But that's not what it's doing. What it's doing is it's considering the claim. It's not considering whether it has its own jurisdiction. It's just saying, do we really have a controversy here?
it's saying, I don't have the power, I don't have the jurisdiction to resolve a conflict that doesn't exist. There is no live controversy for me to decide, and so I have no
I think
jurisdiction.
that's just another way of saying that it's not a viable claim, which is different than whether or not a court has adjudicated power to make that determination. Those are two separate. That's a rabbit hole. I'm not sure it even plays out here because here there's no issue of timing of raising the issue.
No,
Yeah.
but the thing that makes it important is, there's some case law out there saying, and this is what's just, going back, this is why it shouldn't be this way, is that if a plaintiff includes a declaratory judgment cause of action, then they have insulated themselves from any potential for fees under the statute.
That came through y'all's briefing loud and clear, and I guess the response to that is call your legislator. Have them change the offer of judgment statute to include claims of equity, and wrap them all up together in the offer of judgment statute. They haven't, because heaven knows this is not the first time this issue has come up and been litigated about, dang it, they're bringing in a deck action, they're bringing in a specific performance count or what have you, and it's gumming up my ability to try to get them on the hook for fees for the 10 other counts that are all seeking money damages.
But the courts have not hesitated to work around, the statute.
Your
And we
best
see that
case.
for the true relief exception.
Tell me, Javelana is not your best case.
I'm sorry,
Javelana is your best case.
it is one of the best cases, yes.
Is there one that you would have us look to as better than Javelana at your point?
Or is it like picking your favorite kid? You don't want
I like this court's decision from Polk County versus Highlands in the Woods.
I think that was factually a little bit off, or less compelling than John wanted, but let me go to the other point here, which is the good faith. I
Okay,
made a $1,000 offer in what looks to me like a gazillion-dollar dispute, at least multiple millions. And I think your argument, reduced to simple terms, is right, because we didn't think we had any exposure, and it turned out to be right. So that's good enough.
and it's a little bit broader than that, but essentially, the standard for measure, first of all, it's the offeree's burden to prove a lack of good faith, not the offerer's burden
And
to
since
prove.
you didn't really deal with that, and we had to step up on the burden, because you all were both briefing this sort of prophylactically, I think.
Essentially, I think there was some argument about it at the hearing, but there were no
The
allegations.
trial judge, I think, expressly said, I don't have to go there.
Yeah.
Because I'm
That's
disposing of this on point one, but we could disagree with him on
That's
that, and we would need to look at this.
And so I guess, turning Berkeley's argument back on it says that you can't apply the tipsy coachman doctrine when the court hasn't made necessary findings of fact. Not sure I entirely agree with that, but that's the argument that they've raised with respect to the intra-corporate conspiracy doctrine argument that the bank raised. And so I guess the first thing that I would say about it is, the court would have to decide whether the trial court was required to make factual determinations with respect to the good faith evidence, and whether failure to do
I
that.
think this is where Judge Lucas got the alter ego piece from, because I think the argument you made in your brief was the bank had a reasonable basis to believe in its minimal exposure. It's not Tempo's alter ego, and nobody ever alleged that. That was part of the argument that you made in the briefing, if I'm not mistaken. And it had no, what we've already talked about on the merits.
I think it's important to note that the offer of judgment came 3 years after the case had been filed. There have been the tortious interference and conspiracy claims were already gone. They had been dismissed, and there have been 20 depositions taken. And so this was not a knee-jerk, let's send them a $1,000 offer. I mean, this was the result of some careful and diligent study and analysis based on the discovery that had occurred and what the trial court had already done. And so the fact that it was, what Berkeley calls a nominal offer doesn't matter. I mean, the amount of the offer doesn't matter. What matters is whether the bank had a reasonable but subjective belief that the offer tracked its potential for liability. And it did, and it was right.
Is there some tension between this good faith offer / nominal offer requirement in the text of 768.79? Because there's nothing in 768.79 that prohibits nominal offers of judgment, at least not from my reading. I'm not even sure that there's anything that requires good faith. This is a court created doctrine that we all have to now work with.
Right.
Correct?
Right. Which, no one had to go to the legislature for that one. But, I think I just don't think there is any evidence here that was presented by Berkeley that the offers were not the result of careful
There's no
study.
reason to go there because the trial judge foreclosed it. So I think the whole discussion of burden is precipitous. Probably not, but it's understandable, and we appreciate getting the briefing on it, because it's something I think we have to look at least in completing the analysis, assuming we don't see some other resolution here based on the resolution.
Right, certainly it would be a fallback argument, I think, if the court were inclined.
Yes, this is probably around trail. You reminded us of the timing that the offer was made. When the offer was made, were we relative to the stipulation on declaratory judgment?
I do not think it had occurred yet, although I'm not going to be wrong about that.
Maybe you're on the policy number.
I think that there had been, the court noted in its order that the bank had, maintained from the very get-go that it was seeking no relief under the rider. And so, and And I think the evidence was that Berkeley had known that since at least 2017. And so there was no, thought that the declaratory judgment action was live and was disputed in any meaningful way, because the bank had never made any secret of the fact that it was asserting no rights under the rider. And so the declaratory judgment action was dead on arrival. I mean, the reason it went away is because the bank said, we have been telling you over and over, we have no interest in pursuing any relief against Berkeley under the rider. We're not going to, we haven't. And so essentially what Berkeley was saying, and this is why I think the true relief here is really a relief related to damages, is that Berkeley's theory on the declaratory judgment is, yeah, but we filed it as a defensive move. We want to make sure that you're not going to come back later and say that you're entitled to damages against us under the rider, which you can then offset against the damages that we're entitled to collect for the breach of contract. That's why the declaratory judgment action is really a claim for the true relief is a claim for damages. There is no independent value. It was all about the offset that a claim under the rider could generate with respect to Berkeley's breach of contract claim. I will reserve the rest of my time for rebuttal. Thank you.
5 minutes to go.
Again,
Good morning.
CC Brogan on behalf of Berkeley Insurance Company, the FMLE here. I'll jump in where you started, Judge Lippert, asking about what you would do procedurally if you were inclined to reverse on the merits. And I've given that a lot of thought while I've been sitting over there, and I don't have a great answer at the moment, but I didn't want to leave the question unanswered, and I wanted to offer that perhaps that's something we could brief if that's something you all needed further. I think Ms. Blank might be right. I'm not sure that it would be moved depending on what you did, especially with the declaratory judgment disposed of, but it could also certainly create quite a mess. So probably, and I apologize for not thinking about that before arriving today, but I'd be happy to answer that question in writing separately if you'd like us to. On the cost issue that you were asking about, the bank mentions that the order denied everything. It doesn't matter if it was silent, but it was plain if it's a prevailing party cost issue, and then that's a pretty basic error in theory. And if it's not there and you don't tell the trial court that you made this error, then you need to tell them you waived it. But in any event, if you all were not inclined, if you rather were inclined to reverse on the cost issue, you would still need to remand it because we have apportionment issues and all sorts of things that would happen in the trial court. On the jurisdictional issue that was raised about whether there was jurisdiction, the trial court had jurisdiction. That is a complete non-starter for some of the issues, reasons that I think some of your questions were getting at, Judge Lucas, but also the trial court thought it had jurisdiction, it resolved the claim, nobody's appealed it, so it's settled. And it was not even pointed out as an issue until the reply brief, which is also not.
Well, in theory, you can raise subject matter jurisdiction anytime.
Well, that's fair. Although,
Which may be why it's getting wedged into that way.
that's perhaps true. But it certainly is not brief. We don't have any type of case law discussion on it in any event. It wasn't appealed, so it's dead and gone.
Let's talk about the elephant here,
Yeah.
which is the debt relief, right?
Mm-hmm.
Your argument necessarily is that the declaratory relief claim had independent value because it cut off the bank's ability to go after you on the bond. But doesn't the trial court's ruling in that regard, it operates to insulate Berkeley from a monetary liability. So one view of this is, it's all about money.
Perhaps, but here's the difference here in this situation. The bank says that that's a restating of the breach of contract claims, but Berkeley's got no breach. We just beat that to death. Berkeley's got no breach of contract claim against the bank. So that's apparently a breach of contract claim Berkeley has against someone else, not the party with whom this deck action, they're engaged in. But even if you try to convert that to monetary relief, here's what's different about this case from Javelana or the Highlands in the Woods case or any of that. Even if you tried to convert it to monetary relief, this would be a declaration about whether Berkeley owes money, whether that's $0 or $10 million or something in between. How much money Berkeley is going to have to pay something else, not how much money Berkeley is going to be getting from somewhere else. And in every single one of those other cases where an equitable claim is found to be true monetary relief, it is always that the DEC action gets subsumed within the monetary relief claims because the plaintiff is seeking compensation. In Highland in the Woods, in Javelana, in all of those cases, the plaintiff is seeking compensation, just as Berkeley is here from the bank, but the DEC action is also essentially, and I'm certainly paraphrasing here, declare that I have a right to seek compensation against that same party, which is not what we have going on here. Here, we've got Berkeley seeking compensation for the bank from one thing and saying, I have a DEC action to make sure that I don't not just owe the bank, but that I don't have obligations under this. Like, it's like an insurance policy. Like when an insurer wants to know what its obligations are under its policy, it's the same thing here. So it is not, I don't think it is a claim for monetary relief. I think it is exactly like an insurer would do. But even if you try to frame it that way, it isn't the same thing because Berkeley's not seeking to recover from the same, it's not between Berkeley and the bank. It's not Berkeley seeking money from the bank. Therefore, Berkeley's debt claim is not being subsumed.
Well, Berkeley was definitely asking to be effectively immunized from liability to the bank on the bond, and they got that.
For sure, but that's not the same thing as Berkeley then seeking to recover against the bank. And therefore, the DEC action relief being subsumed within
So,
those
I mean,
claims.
your theory, that's the exact same as a coverage determination for purposes of analyzing true relief.
Yes, yes. Am I going to tell you it's exactly the same? No, it's not. But is it much closer to that than the alternative, where those cases where what's really happening is the question is whether the DEC action or equitable relief claim is being subsumed within those other affirmative relief claims? It's definitely not that. And it is much more like the insurance situation. So this is an independent claim. This is not a claim that Berkeley said at the outset, oh, there's no evidence of that. But they were like, oh, let's try to beat this offer of judgment we think might come one day down the road and we'll throw this DEC claim in. This is one heck of a case with millions and millions of dollars in dispute. And one way that people are potentially going to be looking to Berkeley, like an insurance company, as a surety company, is under its rider. And it wants to know what's what under that rider and who it's obligated to, if anyone. And Berkeley did actively pursue this claim, by the way. It fought for this claim, and the proposals for settlement were served before the declaratory judgment order. So it did have significant value. Berkeley did want to make sure of its liabilities of any under the bond. And it's independent because, interestingly enough, at the end of the day, whether stipulated or not, Berkeley has relief under this declaratory judgment claim, but it lost on the other claims. I mean, as we just discussed on the merits part of this appeal. So it's absolutely an independent claim, and it is nothing like those other claims. As the board knows, we've also pointed out and argued that this is a nominal, that even if you thought that this was not, even if you thought that this was truly a monetary claim, the declaratory judgment claim, in any event, the offers are nominal. I'm happy to take questions on that. I think that's briefed pretty well between the parties. I know that it is okay to have a nominal offer. It's true that the statute does not have that, but a nominal offer can be okay. Just because you have one doesn't doom a proposal for settlement, but you do have to start looking at things like potential exposure, complexity and closeness of the case, whether the claims survive dispositive motions, whether there's a reasonable relationship between the offer and the potential liability. And when the offer here was made, the bank was facing $9 million in liability. Everything had survived motion to dismiss. Heck, down the road, it survived the first round of summary judgment. This is not a nominal offer kind of case, is the bottom line. I think at the end of the day, the trial court reached the right result here on fees and costs, and this court should affirm, but I don't want to leave anything on the table if there are any questions that you'd like me to answer. All right, thank you.
Thank you. Just a couple of points in rebuttal. The first, the subject matter jurisdiction argument, obviously it is not waived. I mean, it can be raised at any time, it can be raised after this appeal is concluded. And so, no waiver there. I think it's interesting too, the declaratory judgment in this action is not remotely like a declaratory judgment action seeking coverage in the case that Berkeley cites. I think the closer question is what would happen in a case where there is a breach of contract for damages for coverage under the policy, and then a declaratory judgment action that essentially says what Berkeley says here, which is we don't have to pay damages because we don't have coverage obligations under the policy. Isn't that just recasting the contract dispute as a declaratory judgment action when the dispute really involves an action for money damages? That is what is at issue here, is a recast declaratory judgment action that seeks a determination that Berkeley's damages can't be reduced by any amounts it might potentially owe to the bank. And so that is an entirely different concept than the case that Berkeley relies on, where there was no damages claim at all in that case. It was merely a contract interpretation case with no damages involved at all. I think it is an entirely different proposition when the declaratory judgment action really just recasts the breach of contract action. There are no further questions. Thank you. Ask the court to reverse the fee motion and affirm on the merits appeal. Thank you.
Well done, some of the best. Bring it in.
All rise. Thank you. Travel safely.
Thank you. Good job. Thanks. You too, Stacy. It's good to meet you in person.
Job.
You too. Hey, thanks, Joe.